And then in cause number 26, DCCR 0415. Many button. You're charged with a first-degree felony offense of aggravated robbery, and that's from January 27th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In each of these cases, those two cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases.
Judge.
It's admitted in each case. Is there any evidence that Mr. Worlds is not competent?
No, Your Honor.
All right, sir. In cause number 26, DCCR 0361, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding in that case of a deadly weapon. In cause number 26, DCCR 0415, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm also making an affirmative finding in that case of a deadly weapon. Now, in cause number 24, DCCR 1721, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 8th of 2024 for the state jail felony offense of unauthorized use of a motor vehicle, and that was a 5-year deferred probation. Is that correct?
Yes.
And then in cause number 24, DCCR 1420, I also have a motion to revoke your unadjudicated probation. This shows you were placed on probation October 8th of 2024 for evading arrest or detention with a motor vehicle, a 3rd-degree felony. That was also a 5-year deferred probation. Is that also correct?
Yes.
Each of these cases allege that you have violated your probations. Count 1 in each case alleges that you committed that new offense of aggravated assault with a deadly weapon January 21st of 2026, the one that we just went through. Is that true or not true?
Sure.
Judge, to save time, plead to count 5 and count 7 in both of those motions. And I'll abandon the rest if it's sufficient.
They're different. The motions are different. I'm not sure if that matters.
But those are the same counts.
There's not a
Same allegations.
there's not a count 7 in 1721.
1420, there's a count 7.
Correct.
Count 5 in the other one, and it's the same as count 7.
So 5 in one case, 7 in the other.
Yes, Judge.
So in cause number 24, DCCR 1721, it also alleges in count 5 that you possessed and used a firearm, namely a handgun, to fire shots at 2 people on January 21st of 2026. And is that true or not true? And then in cause number 24, DCCR 1420, count 7, in that case also alleges that same violation of firing the handgun. Is that true or not true?
True.
All right. So did you enter your pleas of true to counts 1 and 7 in 1420 and 1 and 5 in 1721 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have also here on the tablet some documents in those 2 cases that have your signature on them that the state's marked as Exhibit 1. Did you also go over these with Mr. Parker? And do you understand them as well? And you also understand if I follow these agreements, you'll be waiving or giving up any right to appeal. State tenders number 1 in each of those cases.
Objection.
It's admitted. All right, Mr. Worlds, in cause number 24, DCCR 1721, find that you entered those pleas to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1. Hold on, I just pulled the wrong one up. I looked at the wrong thing. What's the agreement on?
2 years TDC and 2 years state jail.
Gotcha. So in cause number 24, DCCR 1420, also find that you entered your pleas of true freely and voluntarily. Find counts 1 and 7 true. Find sufficient evidence at this time to find you guilty, and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. In all of these cases, I'm going to hand you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Plucker. All right, good luck to you, sir. You can go back with the bailiff.
Here you go. Hey.
I've got the first 2.
Oh, you did?
Mm-hmm. Did you already do it?
There's 2 F19s and F20.
Hey, ma'am, are you Ebony Broussard?
Yes, ma'am.
And will your client, it's my understanding she's going to just enter pleas unagreed on the motions.
Request to bond, that's correct.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Will your client waive the formal reading of the motion in each of the cases?
By formal reading.
Ms. Broussard, in cause number 19-32518, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the 3rd-degree felony offense of escape while arrested, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am, it is.
And then in cause number 19-32806, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for assault on a peace officer, a 2nd-degree felony. That was also a 10-year deferred probation. Is that correct?
Yes, ma'am, it is.
And then in cause number 21-36615, also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 12th of 2021 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Hold on. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of public intoxication January 23rd of 2026. And is that true or not true?
Yes, ma'am, it is.
True.
Yes, ma'am.
Count 2 in each case alleges that you committed the offense of possession of a controlled substance January 23rd of 2026. And is that true or not true?
Yes, ma'am, it is.
True.
Yes, ma'am.
Count 3 in each case alleges that you possessed an illegal drug, namely PCP, January 23rd of 2026. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, ma'am, true.
Thank you. Count 4 alleges that you became intoxicated or was under the influence of an intoxicating substance on January 23rd, 2026. Is that true or not true?
Yes, ma'am, it is true.
And then finally, count 5 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
No, ma'am. That's not true.
You're all caught up on your
Yes,
fees in
ma'am.
every single case?
Is there a date, Your Honor, or is it just,
So in cause number 19-32518, the allegation in count 5 is that as of February 2nd, 2026, you were $1,640 in arrears. Is that true or not true?
Oh, that was true in February, but I'm caught up on it.
Okay.
it's
She
not,
said I was just $22 behind.
it's not, it's not,
Oh, in February?
February, you were
Oh,
behind.
yes, ma'am, that was true in
Okay.
February.
In cause number 19-32806, count 5 alleges as of February 2nd, 2026, you're $965 behind. Is that true?
Yes, ma'am.
And then in cause number 21-36615, the allegation in count 5 is that as of February 2nd, 2026, you were $555 behind. Is that true?
Yes, ma'am, that was true.
Did you enter your,
where,
and we'll get, when we come back, we can get the actual amount and where she is on with an updated report. Did you enter your pleas of true to counts 1 through 5 in each case freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to all of those counts because they're actually true?
Yes, ma'am, I did.
All right, then in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty in each case and revoke your probation. However, I'm going to order an updated report from the pre-sentence probation department, and then we will come back at a later date for sentencing. Obviously, anything that you think is important for me to know, get that information to Mr. Kimler and he'll present it to me on your behalf when we come back.
Yes, ma'am.
yeah, plus bonds, I know the court may be a bit reluctant to do that because of her conditions that she, was under the influence of intoxicating substance, particularly PCP.
Already set bonds.
Oh, yeah.
There was a request and they were set in each case. I'm not going to modify those amounts. All right, we'll see you back at sentencing. Anything?
Sorry.
Yes, ma'am.
Just since,
Hang on just a second. Go ahead.
just because these officers have been here this morning, I would just like the opportunity to ask if they have anything with respect to Ms. Broussard. I know Ms. Richard as a supervisor is here and has diligent notes on it. If there's anything that they feel is important for the court to note at this point, or would you rather wait?
I would rather it be either in the update or come then because in 6 weeks, I'll probably have forgotten what we talked about.
No, that's fine.
I appreciate y'all being here. I'm sorry this one ended up last, but yeah, let's just get an updated report, get everything you need in there. And then if there's any other testimony, we'll get that at those sentencing hearings. Thank y'all for being here.
May I just ask, in the instance that she were to make those bonds, would there be anything that you all would recommend with respect to?
They're $100,000 in each case. There's a GPS and a drug patch already ordered. Anything else that y'all would want? I figured that would cover it.
Yeah.
All right, thank you. You can go back with the bailiff.
Yes, ma'am.
Oh, I'm sorry, she needs your thumb. All right, are you Francisco Garza?
Francisco Garza.
And this is 25 DCCR 1623. I'm going to take judicial notice of the court's file. Mr. Garza was examined by Dr. Capon for competency to stand trial. I've received that report dated April 21st of 2026. The finding in his report is that Mr. Garza is currently not competent to stand trial and that inpatient treatment for restoration of competency would be warranted at this time. Is there any other evidence with regard to competency?
No, Your Honor. Okay.
All right, then at this time, I am going to find based on that report that Mr. Garza is not competent to stand trial. Order inpatient competency restoration treatment for a period of not to exceed 120 days from the date he gets to the appropriate facility, and then we will await a report from them at that time. You're going to go to a hospital so that they can get you where you can understand everything. Okay, Mr. Garza, you need to cooperate with them. All right, and then we'll get you back here to go through your case. Okay, you can go back with the bailiff. Hi, you're Alethea McDonald. Is that your name? And this is clause number 26 DCCR 0348. And Ms. McDonald was evaluated for competency to stand trial by Dr. Capon. I've received that report dated April 21st of 2026. The finding in his report is that Ms. McDonald is currently not competent to stand trial, and inpatient treatment would be required for competency restoration. Is there any other evidence with regard to competency?
No, not from the state judge.
All right, then at this time, I'm going to find that Ms. McDonald is currently not competent to stand trial, find that inpatient treatment is necessary for competency restoration, and order her to the appropriate facility for a period of not to exceed 120 days from the date she gets to that facility for competency restoration. All right, you can go back with the bailiff. You can go to the back.
In this courtroom session, several serious criminal cases were handled. A man named Mr. Worlds pleaded guilty to aggravated assault with a deadly weapon and aggravated robbery, both first-degree felonies, and received 2 20-year prison sentences that will run at the same time. He also admitted violating probation in 2 older felony cases by committing the new violent crimes and firing a handgun, leading to additional 2-year sentences that also run concurrently. Another defendant, Ebony Broussard, admitted violating probation in multiple cases involving escape, assault on a peace officer, and drug possession by committing new offenses including public intoxication, PCP possession, and failing to stay current on court fees. The judge revoked her probation but delayed sentencing until updated reports are completed. Finally, 2 defendants, Francis Hill Garza and Alethea McDonald, were found mentally incompetent to stand trial after psychiatric evaluations, so the judge ordered both to be sent to inpatient treatment facilities for competency restoration before their cases can continue.